Welcome to the Block and Tackle Show, hosted by Carl Block. Carl is a partner in the law firm of Loeb & Loeb here in Los Angeles, California. He will be tackling some of the biggest issues in business today. Listen, learn, and enjoy as he leaves no stone unturned during deep conversations with some of today's most amazing business leaders. Welcome to the show.
Okay. Now, there's another thing that you do in alternative dispute resolution besides arbitration. The audience knows that arbitration is like a private court situation where you decide a dispute, who wins, who loses, if there's damages, and how much. But another very common tool in alternative dispute resolution is mediation. And you're also a mediator, aren't you?
That's correct. I am a mediator as well.
Okay. Now, first, let me say this. Do you find, because you've litigated for so many years and you've seen all kinds of disputes, that you feel like it's pretty easy for you to appreciate the perspective of each of the litigants and understand what it takes to actually get a consensual agreement to settle through a mediation process?
Let me back up a little bit.
Okay.
For your audience, mediation is when the neutral has one-on-one conversations with each side that are confidential and goes back and forth and tries to settle the case. Every case is different. Every litigant is different. Every lawyer is different. Sometimes, as a mediator, you're being evaluative and telling lawyers and the litigants what you think about the case. Sometimes you're engaging in negotiations. More often than not, you're trying to creatively get everybody to a common general space of where we think the case should settle based on our experience. There's some cases where a plaintiff has a particularly emotional case and they feel the need to tell their story, which is a very effective way of getting people to start to realize they want to settle once they've been able to vent. So this may not be a direct answer to your question, but every mediation is different. A good mediator can find out how much the paying party is willing to pay to settle the case and deliver that to the plaintiff who gets to make the decision. And it's a long process. I mean, they usually take at least a day. Most of them are one day, I should say. And there's a cadence during the day to the negotiations. But the job of the mediator is to bring resolution, and you're working with both sides and you're listening to their legal arguments, you're looking at their evidence. I mean, it may come down to the mediator expressing an opinion that this particular document that, say the defense needs to win the case isn't admissible for a certain reason, or that the plaintiff's not going to be able to tell part of their story. So every case has a different nuance and different variations on a theme of different techniques of how to settle the cases.
Okay. And there's a lot in there, and I'm glad you said it because we can unpack it. But I also want to back up a second too, because I think I got ahead of myself. So one thing that I'm not sure the audience knows is that if you're in arbitration or you're in court already with a dispute, it would be extremely unusual for the judge or the arbitrator to act as the mediator. Is that right?
It would be extremely unusual for the judge to, because you'd have to stipulate to it, and very few lawyers would do that. And I'll tell you why in a second. It's a little more common in arbitration, but still not as common. And the reason it's not as common is because in order to settle the case, you're telling the mediator certain things that you perhaps wouldn't tell a judge or an arbitrator. For example, if you're the plaintiff, you might say, listen, I recognize I don't have a strong case, but this is where I'm trying to get. And you really wouldn't want to say that to the trier of fact. So it does happen from time to time. It's called mediation arbitration. But you're really, as the neutral, you're changing hats and acting in a different role.
Yeah, and simply put, if you are the mediator and the arbitrator, and acting as a mediator, you have a litigant who says, yeah, I really have these weaknesses in my case. You can't forget about that if the case doesn't settle and then you arbitrate it. It's in your brain. And you can say that you will, but human nature is human nature.
Well, hopefully a good arbitrator will look only at the evidence and see if the plaintiff has met their burden of proof for all the elements of each claim. But I think the lawyers are often reluctant to let an arbitrator or a judge mediate, but it is more common in mediation than in arbitration. Excuse me. It is more common in arbitration than in court to let the trier of fact also be the mediator.
Okay. Now let's also take one step back. As opposed to arbitration and court, which you commence a process where you have a court case or an arbitration, you don't have to have any court process to mediate. Is that right?
That's right. It's done outside. Well, there are settlement conferences within the court system, but that's a slightly different animal. But to mediate, there's a lot of flavors of mediation, just like there's a lot of flavors of arbitration. Almost every case will ultimately be mediated, either at the request of the parties or being ordered to by a judge or suggested to by an arbitrator. You can mediate a case prior to arbitration or initiating a lawsuit or after. In fact, there's many arbitration provisions that require the parties to mediate in good faith before filing either a complaint in court or a demand for arbitration. So it can happen at any point, and it can happen multiple times.
Okay, and so you could have a commercial contract, for example, where it says if there's a dispute, you have to mediate within so many days or something like that. Again, subject to the creativity of the people who draft the alternative dispute resolution provisions.
That's right.
And then there's a mediation where the mediator will conduct the mediation subject to the mediator's best efforts. You mentioned that you will talk to litigants or potential litigants in advance of the mediation to try to get a flavor of things, which I think is a very nice thing for what I've seen clients of mine go through. That's just my personal view.
Right.
But again, you don't even need a case.
Now, right. I was going to say when a mediation is scheduled, I always speak privately to the lawyers for each side before the mediation starts. And each side will be submitting to me either a letter or a brief, which is a legal document explaining their position, the negotiations thus far, providing me with a couple of key documents. And then I follow up and I ask them all the things that would be helpful in the negotiation, such as if it was the plaintiff, what happened and how much money does this person really expect to get to settle? Do you have a problem communicating with the other lawyer? Can I put you in rooms together? Should I keep you separate? Is there something that's not in the papers that I need to know? Are there any personality quirks I need to know about? All the types of things that would help any negotiator bring the parties together.
Understood. And that could include what do you think the other side wants, or what do you think the other side's hangups to settlement, or any other question? It's your baby.
Not only any other question, but something that your audience probably should know is that the mediation is confidential, more confidential than the arbitration. So nothing is admissible in evidence. If somebody shows somebody else a document, they can always subpoena it. So obviously, if you show somebody a document of mediation, you can't later use it to keep it out of court. But nobody can go to court after a mediation and say, so-and-so said this at the mediation. That would be completely inadmissible.
Okay. And for example, if you conduct a mediation and you got served with a subpoena for a deposition or to testify in court, you could get it quashed. And it's pretty well known that
Right.
that you can't be forced to testify, and you can't have to show your notes or emails or anything else.
Correct.
And the mediation briefs are confidential. They can't be used. The evidence that you have in the mediation can't be used. But as you say, if it's a business record of one of the parties, it can be requested to be produced, or from a third party by subpoena. That's fine. But
Right.
whatever happens within those quote walls of the mediation, it's all confidential.
That's right. There is no ability to subpoena the mediator. There's no ability to talk about what happened. It's highly confidential, and I can say this, it's going to happen in almost every case. There will be a mediation, and typically the sooner you do it, the better. There are occasions where cases aren't ripe for mediation until there's been some discovery, but typically mediations are successful. And sometimes the case doesn't settle, but it does move the parties closer, and it takes a second mediation after a few rounds of discovery.
So it could, what you're saying is you might have it one day of mediation, and at the end of that day of mediation, you could say either I'm never going to get this settled, and I may make some kind of mediator's proposal that I'm sure you'll talk about in a second, or you could say, I think I can do this with more time. And
that's right. That's right. Or it could be, this isn't quite ripe yet until, the defendant deposes the plaintiff, or until certain financial documents are produced so somebody can quantify damages, or till the experts looked at accounting records or things of that nature. Or sometimes it just takes more than one business day to negotiate. Some deals are complicated, some are simple and are just about money, but every mediation is different. You raise the issue of a mediator's proposal. That's there are a lot of different tools we use to settle cases. That's one that's becoming increasingly common in my experience, where the mediators can make a proposal to both sides. Say it was a simple case where the only issue is money, and each side will tell the mediator if they accept. If one side says no, they'll never know if the other side accepted, because there's no deal. But if you said yes and there's no deal, you'd know the other side said no. But typically, most good mediators know where the sweet spot is and can make a competent proposal if it comes to that. But not every case is appropriate for a proposal.
Understood. The theory being that if you make that proposal, you're giving your evaluation. This is what I think is fair to settle this. You give that to both parties, and they either accept it or they don't.
Right. And before you do that, it's sort of the last part
Sure.
in a case where you're going to do that. And sometimes you move them not by, absolute dollar values back and forth, but you can negotiate with brackets. And I'm sure your audience is aware of that, where the plaintiff might say, we'll come down to $1 million if the other side comes up to 400,000, and the other side says, well, we'll come up to, 300,000 if they come down to 800. And you've got, instead of numbers going back and forth, you can have brackets going back and forth. There's an infinite number of ways to do this, but that's one of the more common approaches.
And it probably takes somebody very experienced to do this.
Yes.
So the other thing about mediation, so if you have a dispute where it might be covered by insurance, you can actually, with the party's consent, talk to the insurance company. You can bring the insurance company to the mediation, can't you?
Not only can we, but typically we require it. All decision makers have to be there, or it's hard to cut a deal. If the insurance company is writing the check, the adjuster is going to have to be present. Otherwise, the insured has no ability to resolve the dispute.
And in it, ostensibly, if the two parties are litigating something that could indirectly affect a third party, and one of the litigants feels hamstrung because the third party isn't there, and they explain this to you, you can say, well, I really want the third party there because I need to hear from the third party what they will do, what they won't do, because we're trying to resolve a dispute here.
That can be done. The mediator can't compel the third party to participate. If a judge has ordered mediation, the judge only has jurisdiction over the parties. It's a voluntary process for a third party, and if they want to participate, great. If not, it's just one more challenge.
Okay, but one of the reasons why I think you said that so many cases go to mediation, is it true that the vast majority of cases actually settle? They don't go to conclusion, especially in court?
Yeah, I've heard a lot of different statistics, but the most common one is 92% of cases settle. Well, the range I've heard is 90 to 94%. And of that, a lot of those cases settle in mediation.
Okay. So I think we've done a pretty good job of discussing arbitration, of course, and mediation. Let me just ask you this last topic. Would you like to tell the audience any tips and tricks about how to, not annoy the arbitrator or the mediator, or how to make things more effective so that things can be resolved?
Yeah, I think that when you arbitrate a case, the JAMS rules and other rules require the parties to voluntarily disclose their documents and their witnesses. And when that's not done, it doesn't bode well for the party withholding documents or refusing to cooperate. One of the advantages of arbitration, quite frankly, is the ability for the lawyers to control the proceedings if they can agree and cooperate to some extent and keep fees down. And when there's discovery disputes that are manufactured, it gets very pricey and doesn't really help anybody in the case. I also think it's very helpful to understand that the arbitrator, at least if it's coming from a pool of qualified people, will have a full understanding of the case before the phone call or the virtual hearing or the in-person hearing starts. And there's no need to kind of wind up and spend, an extra day of time arguing over things that all the lawyers to the arbitration know are going to be admitted into evidence. And I think that the most important thing, if you really want to talk about it for your audience, is how you draft that arbitration provision. If you think about the business that you run and the types of disputes you run into, you want to try to create a provision that facilitates resolving those disputes. So, for example, if you're a bank and you're doing loans, you want to have the ability to have a mediation before filing arbitration to see if you could resolve it, because you're going to be speaking to your borrower anyway. If you're an insurance company and you've got an insured, you want to make sure that you're going to be able to deal with the insured and their lawyer and cover not just contract claims, but any kind of tort claims or statutory claims. So I think it really goes back to how you can forecast the types of disputes you'll likely face and how creative your lawyers can be. And again, there is a good arbitration provision workbook on the JAMS website.
Okay. And of course, be polite to the arbitrator and mediator, be respectful, answer the arbitrator or mediator's questions, be collaborative.
It doesn't work well when lawyers or their clients are impolite or not helpful. I mean, one of the advantages, as I said, of the arbitration process is you really get to the meat of the matter, and the arbitrators typically have the relevant expertise, and they've seen these types of disputes before, and they want to get to the meat of it. And all the other distractions just tend to cost money.
So, Dan, this has been a very, very informative episode today about both arbitration and mediation. I think for our audience that doesn't litigate or if they're lawyers but never get involved in any kind of disputes. This is really informative. If the audience wants to know more about the kinds of matters, the areas of law that you specialize in, arbitrating and mediating, where can they find that out?
Sure. I work for an organization called JAMS, JAMS, and the website is www.jamsadr.com. The ADR stands for Alternative Dispute Resolution. And you can find my bio there and a link to my case manager, and it'll explain all the types of cases I handle.
Okay. And for the audience, in case you forgot, it's Dan Platt, Platt, and you'll find his bio at JAMS. Okay. I really appreciate you coming. And for the audience, thanks for tuning in to this episode of the Block and Tackle Show.
Thank you.
Thanks for tuning in. If you want more info on the show, please visit blockandtackleshow.com. And you can also email me at carl@blockandtackleshow.com. Thanks for tuning in.